Firstly, I must thank the Middle East branch of the Institute of Chartered Shipbrokers for organizing this webinar. The Middle East branch is a very active branch, regularly conducting various events for their members and the shipping community at large. And for this, I must thank the office bearers who work tirelessly behind the scenes to organize their events. Details of the Institute of Chartered Shipbrokers and the Middle East branch is available at the end of the presentation should you wish to know more about them. I understand from the organizers that the sign up for this webinar is more than 400. I believe more than 200 have already signed up, with participants all over from Europe, Africa, and Asia. Thank you. I am based at Singapore and I'm involved in dealing with shipping related issues for my clients in and around this region. My intention of this talk is to broadly talk on the issues which have arisen due to COVID-19, at least on the basis of what I know. I would welcome participants to share their experience, particularly if I have missed out any specific points. I would also welcome participants that should they have any questions, they should put it in the chat box so that this can be responded at the end of the presentation. I'm sure that all of you who are attending this webinar would like to know answers to these common questions. What happens if you're unable to get your bills of lading or a delivery order or a letter of indemnity due to the present circumstances? What happens if you have submitted your bills of lading to the bank so that they can in turn transmit it to the buyer's bank, but are unable to do so as there are no courier services available at the present moment? What happens if your cargo cannot be moved to destination due to issues arising during the voyage? What is the impact of force majeure to your operations? By the end of this presentation, I hope to be able to answer these questions so that you could consider options available should similar issues arise in your day-to-day operations. What I propose to do is to use this outline. I will be speaking on the present situation we are all facing and which ranges from a lockdown, near lockdown, movement control order, circuit breaker, etc. Basically, what all governments have done is to avoid the spread of the virus by clamping the movement of people. While this strategy is obviously the correct one, given the propensity of this virus to spread through contact between individuals, it does have an impact on ongoing business. Shipping, as you're aware, is a derived demand, and lockdowns such as these would bring down the demand in most goods and commodities. At the same time, there would also be an increase in demand of some specific goods such as disinfectants, face masks, foodstuffs, etc. It will also have an impact on the supply side, given that factories may either be no longer working or if working at a reduced capacity due to issues that they may face with respect to availability of labor and or raw materials for manufacture. Cargo may have already been shipped prior to the lockdown coming into effect. For the majority of these cargoes, the transit would have been completed, and for some, the transit may still be continuing. Given that these cargoes have been loaded prior to this lockdown, parties would not have been aware and therefore could not have avoided the effects of this present situation. However, with cargoes which are yet to be loaded, the trade would generally be aware of the issues which may arise, and therefore they should consider appropriate strategies to deal with the same. In this regard, I will be speaking on documentary issues arising in the liner industry, on bills of lading, delivery order, letters of indemnity, together with practical issues arising out of this. while the break and break bulk industry would also be facing similar issues. I believe, given that the number of parties involved in the liner industry is way much more, this industry will continue to face more severe stress till the situation comes back to normalcy. While this is a trying time, it is also an opportunity to learn from this so as to make systems and procedures better for the future. I believe that we have exciting times ahead with technology helping us to make all the systems and processes more efficient. I'm sure that you're all aware of the numbers affected by coronavirus. Here is a map which is updated to show a spread of infections.
Jagan, while you pause, I'm just going to say there are some people saying they're not able to listen. On the bottom left of your screen, you have an option to connect to audio. If you have the mobile, you'll have to just swipe left and tap the audio screen. If you have any difficulty, please write in the chat box. Our admin person will help you. Thank you, Jagan. You can continue.
Can you hear me loud and clear? Because my audio is on. I take it that you can hear me. So anyway, this is a map which shows more than 1.5 million people, infected with COVID. More than quite a lot of people are died, and it's a very serious situation. International trade depends on demand and supply. Countries generally produce goods and services in which they are good, and for others, they would import the goods and services which they are, which they require. One of the factors why international trade takes place is due to differences in comparative advantage, and which leads to movement of goods. The international shipping industry is responsible for the carriage of 90%, approximately 90% of the world trade for goods. In this, container shipping is estimated to account for approximately 60% by value. Given that all of you are involved or associated with shipping, I am sure that you are aware of the importance of the bills of lading. I will not specifically touch on the functions, except to state that in my opinion, the most important function is the function of the bill of lading acting as a document of title, which allows a party to transfer constructive possession of goods to another party during the transit of cargo. This transfer obviously facilitates trade. The transfer of cargo by the endorsement of the bills of lading is a unique feature which has developed over the ages to facilitate trade. The duty of a carrier is to deliver the cargo to the holder of the bill of lading, failing which the carrier would be liable for damages for at least the value of the cargo. What are the issues arising related to the bills of lading? The first question we need to ask is whether a bill of lading can be issued in the first instance. In light of the lockdown imposed by the authorities, would the shipping companies or their representatives be able to issue a bill of lading, particularly when movement of persons is restricted? In some jurisdictions, shipping and the associated trade is considered as an essential service, such that it may be possible. However, in other jurisdictions where the lockdown is more severe and that the associated services are not considered as essential, this may be an issue. Issue of bills of lading at the shipper's office is also another possibility. And some carriers do provide forms which can be printed at the shipper's premises. In effect, instead of the bills of lading being printed at the carrier's office, this being printed at the shipper's premises just the location of the printing changes. Other than that, this document is similar and will act as if it had been printed at the carrier's office. Even if the bills of lading can be issued, the question is whether this could be couriered from the carrier's office to the shipper, from the shipper to his bank, and from the bank to the counterparty bank, etc., consignee, etc. If it is not possible during this period, the options to consider would be the issue of a C-way bill or a telex release, also called as a surrender BL. A C-way bill cannot be negotiated, and therefore it only has two functions. It acts as a receipt and is evidence of a contract of carriage. It can either be issued in hard copy or soft copy. A carrier would deliver the cargo at destination to the person or company described as the consignee in the C-way bill. A telex release or a surrender bill of lading is basically the surrender of the original bills of lading to the carrier, either at the load port or at any of the other offices of the carrier, with a request to the carrier to release the cargo to consignee. In this way, the requirement of hard copy of the bills of lading can be obviated. Another option is the use of electronic bills of lading. Electronic bills of lading have been in existence for more than 20 years, the oldest being Bolero. Up till now, traction has not been sufficient to make this a norm. The low adoption rates, in my view, are perhaps due to the investment needed for new IT systems, together with attendant cyber risk. While there are obvious advantages to use electronic platforms instead of relying on paper documents, the fact is that laws are yet to develop to ensure that there is functional equivalence of electronic documents vis-a-vis paper documents. So what are the legal issues arising from the use of an electronic bills of lading? Under English law, invariably most of the bills of lading do provide for English law as a law of the contract or some other common law jurisdiction. The bill of lading is a document of title. The title of the goods resides in the bill and which can be transferred with the transfer of the bill of lading. Accordingly, whoever has the bill of lading has the right of possession to the goods. Cargo can only be transferred or delivered against the presentation of one original bill of lading to the carrier. As an electronic bill of lading cannot be physically presented to the carrier, it therefore cannot be a document of title. COXA 1992, in Singapore we call it the Bills of Lading Act 1992, was legislated to get around some of the issues present in the old law, such as the issue of privity of contract, so as to allow an assignee to stand in the shoes of the shipper to sue the carrier for any loss or damage to goods. However, COXA 1992 does not apply to electronic bills of lading, and therefore holders of electronic bills of lading cannot rely on COXA 1992 to give them any rights to pursue the carrier. To get around this issue, Bolero and ESS docs require that users agree to treat electronic documentation within their systems as a functional and legal equivalent of paper documents, and undertake that they will not challenge the validity of any transaction or communication made on the ground that was made in electronic form instead of paper, or that it is not signed or sealed. In effect, if you want to use an electronic bill of lading for Bolero or ES docs, you need to be a part of the system. The other major EBL is e-title, and which incorporates COXA 1992 into its user agreement, such that it also applies to electronic bills of lading generated in their system. As of now, the international group of P&I clubs and TT Club have approved Bolero, ES docs, and e-title electronic bills of lading. It is also possible to use electronic bills of lading in a blockchain setting. like TradeLens or CargoX. And some of the carriers such as Maersk, PIL and Zim are working on this. The obvious advantage is that one could use the same settings, blockchain, to exchange information for the complete transaction and document control in the supply chain. While there are advantages to the use of this technology, the question is whether this is actually necessary and of benefit. By way of an analogy, do you need a higher performing computer to perform simple functions such as sending emails or browsing? If the operations are indeed complex and there are a lot of document flows, use of a blockchain would indeed be of use. However, given that the role of a carrier is restricted to the carriage and related issue of documents such as bills of lading, delivery order, the use of a blockchain, I believe, would be of more importance to the cargo interest. If a company is already using these technologies well, they can obviously benefit during these trying times. However, could this be implemented at this moment? I believe it is unlikely given that there are time and other constraints arising due to the lockdown. However, it should be in the agenda as and when normalcy is reached. What about delivery orders? A carrier must deliver the cargo to the holder of an original bill of lading, or he may instead issue a delivery order which would entitle the holder to the delivery of the cargo. A ship's delivery order is a legitimate way for a ship owner to deliver cargo under the Carriage of Goods by Sea Act 1992. For a ship's delivery order to have legal effect, it is important that the order contains an undertaking by the carrier to deliver the cargo to the receiver specified in the delivery order. The problems which I have discussed would also apply to the delivery order. Issues posed by the lockdown in place, the availability of bills of lading, and whether these documents could be couriered, delivered to the carrier terminal for delivery. One of the ways to get around in the absence of relevant documents is to present a letter of indemnity, which may be countersigned by a bank, and in which case it is known as a bank guarantee. More of this later. The other alternative being followed in the Indian market is an innovation followed by three carriers, Maersk, MSC, and MACGM. In that they are willing to accept scanned copies of the original bills of lading together with an undertaking that the consignee would deliver the original bills as soon as the situation returns to normalcy. While I'm indeed appreciative of this innovation, I must caution the use of a system such as this due to the attendant risk. It only requires a bad apple to put a carrier on trouble. Hence, I would suggest that for a carrier, prior to following any process or amending the process for delivering cargo, they should give consideration to the risk exposures and whether they can be dealt with, say by getting a letter of indemnity, a bank guarantee, or some such alternate security. In this regard, ITIC, International Transport Intermediaries Club, one of the transport liability insurers to ship agents, had recently posted a circular to their members advising caution related to the release of cargo without original bills of lading. Instead of a paper delivery order, it's quite possible to also use an electronic copy, electronic release systems, thus obviating the necessity of any physical paper required to get delivery. What are the issues arising from this? Again, under COXA 1992, a ship's delivery order needs to be in paper for it to be applicable, as COXA 1992 does not yet apply for electronic records. In the circumstances, you would have the same issues as we discussed for electronic bills of lading. The other issue is, in my opinion, is that if the carrier still has control over the electronic release, it does not actually function as a delivery order, given that the carrier can still deny delivery. In the circumstances, such releases do not act as a delivery order. However, if the release is say through an independent agency or an entity and which does not permit the carrier any right to give any further instructions once the cargo has been released, then arguably it does act as a delivery order. Even if an electronic delivery order or release is provided, the carrier is not off the hook, given that he has a duty to deliver the cargo, particularly when he has some control on the releases. In this regard, the English Court of Appeal in MSC, Material Shipping Company and Glencore, held that a delivery order issued pursuant to a surrender of the bill of lading required an undertaking by the carrier that he would deliver the cargo to the consignee. This was not the same as an obligation to deliver to the first person who submits the code. That is, if the code comes into possession of a third party and who takes delivery, the carrier still remains liable. The other issues related to such transfers is basically the cyber risk. Transport liability policies generally exclude such risks, and therefore a carrier would be well advised to take separate cover for cyber risks. I'm sure all of you are aware of what a letter of indemnity is used in the shipping industry. It's basically used if you do not have the original bills of lading, you may make a request to the carrier to provide a letter of indemnity in lieu of an original bill of lading. Use of a letter of indemnity does not give a right to the cargo interest a right to demand delivery unless this is specifically provided contractually. So if you have a charter party, you may provide it contractually where the owners are obligated to deliver under a letter of indemnity. Otherwise, it is a commercial arrangement, and therefore before accepting any letter of indemnities, a carrier would be well advised to consider the creditworthiness of the party providing the LOI. In the present circumstances, no one will be able to predict what the future would lead to, and therefore it is best to relook at the exposures and whether the signer of the LOI is good for the risk. A better security would be to ask for the LOI to be countersigned by the bank, and who will be jointly and severally liable along with the party requesting. Sometimes banks strike out some of the LOI clauses. This is more prevalent in the liner industry, and instead require that the value of LOI be restricted to the value of cargo, and or the validity period of the LOI is for a shorter period. This puts the carrier on risk, given that should they face a claim to anyone who holds the original bill of lading, they would not be entitled to seek a reimbursement of costs they may have incurred to defend the claim and also pursue the LOI issuer. Additionally, the LOI may expire, but the carrier would still remain on risk as provided under the law. If the bank is unable to provide a LOI due to the same problems faced with lockdowns, a carrier can seek a cash deposit or some other security to facilitate a release of cargo in lieu of a bill of lading. I'm briefly touching on force majeure and frustration. Force majeure in common law countries is a creature of the contract. It must be provided in the contract for someone to declare a force majeure. Basically, they relieve a party from performance of its contractual obligations where that performance is impacted by events outside its control, such as natural disasters or war. I understand that the Middle East branch is planning, that the next talk planned by the Middle East branch is on force majeure. So if you have burning questions on force majeure or issues on force majeure, I think you should attend the next talk, the next webinar, which is planned by them. Frustration, on the other hand, relates to the impossibility of performance. They do not need to be mentioned in the contract as they are available of right. Just one caveat as far as force majeure is concerned. I was talking on the basis of English law. I am aware that the Indian Contract Act does provide does have a provision for force majeure in the contract. So, if you fulfill their requirements, as far as if you fulfill the specific requirement, the specific clause in the Indian Contract Act, it's possible to do. Having said that, invariably, most of the shipping contracts generally incorporate English law, and in which case, it is a creature of the contract. As of now, I do not believe that any liner operator has declared force majeure, as they are continuing to perform the contract, albeit with delays due to suspension of services. However, ports and terminals have declared force majeure, given that they may be unable to perform the contract, with their terminals, with their users. I understand in the Indian market, lots and ports and terminals have declared force majeure. My understanding is they have a licensing arrangement with the government. They also have a terminal agreement with users. And due to this COVID situation, they are unable to perform, and so they have declared. Insofar as a liner operator is concerned, since they are continuing to perform, they have not declared force majeure, to my knowledge. However, the situation may well change for liner operators should there be congestion in the ports and terminals, preventing the berthing of vessels, discharge of containers. This is something which I'm hearing, given that deliveries of cargoes is not taking place due to the lockdowns in place. In fact, Lloyd's List published an article on 9th of April in which they mentioned that box lines are struggling to prevent congestion at import terminals. So, so as to say, watch this space. I think if the congestion is very severe, it is quite possible for a carrier to declare a force majeure, i.e. that they will suspend their services till normalcy returns or abandon the carriage completely. I believe most of the bills of lading contractual terms issued by liner operators do have provisions which would entitle them to abandon carriage in certain circumstances. We would need to see how this develops. In respect of cargo interests, provided they are insured, say under Insured Cargo Clauses A, that is the all risks, they would be entitled to recover for the extra costs which they may incur in forwarding the cargo. What about other alternatives to traditional trading methods? Maersk has already embarked on trade finance, provided the shipment is effected through the lines in some locations. Accordingly, this could be considered further by other carriers who could work in conjunction with banks to offer trade finance or act as collecting agents for payments. This is not novel, or this is not something new. This is already being done by courier companies for couriers which is coming by air. And what I suggest is to extend this also for sea shipments. Alternatively, if there is an ongoing relationship with the contractual parties involved in the sale, they could make payment either in advance or in receipt without using bills of lading. The present situation is novel. You need novel solutions. In order to find a solution, one would need to look at the contractual wordings, jurisdictional issues, and risk exposures. A carrier's duty is to carry and deliver the cargo for which he is paid freight. This freight would not be substantial compared to the value of cargo. Accordingly, a carrier would consider risks prior to agreeing to deliver cargo on the basis of other documents, promises, instead of a bill of lading. I must confess that invariably I'm engaged by carriers, and therefore I may have a bias. In the beginning of my presentation, I did list out some scenarios, and one of those was a bank was unable to courier the documents to its counterpart. In this case, one of the options for the buyer and seller is to agree for the payment to be made on the basis of a copy BL and not an original bill of lading. The OBLs can be returned back to the shipper, and who could in turn surrender it to the carrier with a request that the cargo be released to the consignee. Obviously, there are risks involved, but these risks would be better known to the cargo interest rather than the shipping line or carrier. Alternatively, cargo interests, in this case consignees, and in this matter, I'm actually more concerned for the small and medium enterprises who may not be having the bargaining power with their financial institutions. They should negotiate with the banks to provide some sort of an interim revolving security to the carriers, say a revolving guarantee to facilitate delivery of cargo. The other option perhaps is for cargo interests to lobby with their governments for the provision of an interim legislation such that cargo is handed over to the governments and who provide a guarantee to the carriers. Then they, the governments that is, can give delivery to the cargo interests. In this event, carriers would have a defense to wrongful delivery. It is quite possible for such legislations to be passed quickly in the present situation if it is necessary. And therefore, what is required is perhaps effective lobbying. Finally, we should all learn from the present situation and implement new processes, technology to ensure that there is a business continuity plan even in moments of stress. With this, I have come to the end of my presentation. I must thank you for patiently listening to me, and I would be happy to take questions. Thank you. Okay, the first question I see is if I read it out, it's basically COVID-19 situation.
Apologies for the technical error. It's okay now. We should be able to have a question and answers. Sorry for that inconvenience.
The first question is on this, the Indian ports have issued force majeure. Port circular says port users are being exempted on any rents, penalties, demurrage, any penal berth hires arising out of any less productivity or low discharge rates. I note that cargo in charters are issuing special clauses or taking the shelter of force majeure situation by either not paying any demurrage or paying 50% of the demurrage. The question is, how can owners, operators safeguard their interest to claim demurrage? I assume it is actually for ongoing charters, in which case there would already be a charter party. Insofar as the Indian ports have issued, I did mention in my presentation that the reason why they are declaring a force majeure is because they have licensing arrangements with the government. They have contractual arrangements with their users, and as they are unable to perform, they have a provision in the contract, and they are trying to impose those conditions so that they can suspend or take refuge. In the case of an owner and charterer, well, they are not a party to those contracts. They are not entitled. The charters are not entitled to take refuge on that. You would have to look at their contract, the charter party, to see if there is some provision. Otherwise, the owners are entitled to pursue charters for recovery. As I mentioned earlier, the Middle East branch is conducting another webinar on force majeure, and perhaps that would also be of interest for you to attend. This is this is situation of 14 days from the date of voyage and the shipper declare NOR. I think the issue would actually be whether it's a safe port or not. Uh, there are issues which you would have to consider, because if the vessel cannot enter, or if it's on a voyage charter party, arguably if the duty is shifted to the owners, then the risk changes there. Uh, I do not have any specific answers. You would have to look at the terms of your charter party. Is it a white charter party? What does it say? And then see whether there is a provision which is breached by the owners, such that the risk for for the 14 days goes to owner. But if not, because the owners would be entitled for demurrage.
Okay, Jagan, the next question is about risk factors involved for ship owners, charterers, or traders when LOI is in place. It sounds like a generic question, but maybe looking at the current situation, you could refer to the COVID situation and then provide your views. Thank you.
If you look at the LOI which has been suggested by the IGP and I Club, it's a very extensive LOI, and I would actually recommend the same for carriers to issue that. It not only provides for the carrier to be indemnified for the value of the cargo, but for any cost which may be incurred should someone pursue them. A party who has the original bill of lading is entitled for delivery. So if someone comes to the bill of lading, there would be costs incurred in defending or in pursuing for recovery. So all these costs are possible to recover someone who's issued a LOI on such broad basis. So as far as the ship owner is concerned, he should look at the value of the LOI. That's one. Number two, who is the party giving the LOI? If a party is not good enough for the LOI, why do I say this? Many a times you take a LOI from a party and the party goes bust or is liquidated. So you only have a paper which has no value. So prior to taking an LOI from any party, owners must look at whom are they dealing with, are they good for it. As far as charterers and traders are concerned, well, they are in the counterparty to this. They have to look at their exposures. They have taken cargo. When they have taken cargo, what is their exposure? Something should go wrong. That in a broad nutshell is what the risk factors parties should consider.
Jagan, the next question is about the Congen BL 1994 for cargo short landing at discharge ports, and how charterers can hold the owners responsible, and also what clauses in the bill of lading cover these shortfalls.
The Congen bill of lading, contractually does not have many. I believe it has only 6 or 7 clauses in the reverse side, but it does provide for the incorporation of the GenCon CP. It also does provide for the incorporation of the Hague-Visby rules. The Hague-Visby rules certainly do have provisions for if you look at Article 4.2 A to Q, this COVID situation should fall within one of those. And if owners are unable to prevent, they are compelled to move out, then they would be entitled to a defense. The issue is this is not something which an owner or charterer can actually decide in advance. So we have a situation where no one actually felt it would happen, but it has happened. So we need to deal with it. The owner, in my view, has performed his part, but due to issues which are outside his control, perhaps he's not able to do it. And if the Hague-Visby rules does provide for an escape clause, he would take it. How do you avoid it? I think now with COVID on, if you're taking a contract, I think it's a question of negotiation. What has happened in the past is something which you did not know, but now you know that the situation may change, may turn from bad to worse, or may become better. So parties will negotiate, and if owners are willing to give an absolute guarantee, so be it. I don't see that they would be willing to do, because they would have some problems insofar as their liability cover is concerned. The cover which is given by P&I clubs for their cargo liability.
Thank you, Jagan. We have an interesting question also in regard to the transfer of documents for letters of credit. If a bill of lading is stuck with the advising bank and cannot be couriered to the issuing bank, will the LC become discrepant? Is
Uh,
the beneficiary liable for this delay? Thank you.
I must confess, I'm not involved so much with the banking issue, but my understanding is as soon as you give the BL to the bank, the shipper or the exporter has performed his part of the bargain. Uh, I do not believe the LC will become disciplined because I believe the bank would be notifying their counterpart. So I think this is what I believe. But like I said, I'm not involved in this, so this is the best I can do at this point of time.
Thank you very much, Jagan. We have a question from one of the viewers, when the vessel refuses to accept the scanned BL and insists on the originals being surrendered, but the originals presently in the area which is marked as a containment zone. Yeah. In such cases, as such originals cannot be surrendered, scanned copies can be sent, LOI can be provided, and surrender charges paid, but still to no avail. What is the impact of such refusal on the aspect of demurrage? Thank you.
Uh, well, the carrier is certainly entitled to refuse delivery on a scanned copy because it is not the original bill of lading. You have mentioned a letter of indemnity. Again, the impact would be whether the letter of indemnity is a good enough security. Provided it is countersigned by a bank, I would believe that carriers would generally give a delivery order. The impact of such refusal is that carriers would be entitled for demurrage. The question is whether they do it or not is a commercial decision. I think the common law duty for a carrier is to release cargo only on receipt of a bill of lading. And if it is not done, if the cargo is not taken within the time allowed, carriers would be entitled for demurrage. There are other issues whether the demurrage is valid, whether the cargo is moved. Those are separate things. But yes, in respect to this question, carriers would be entitled for demurrage, irrespective of the fact they refuse to accept a scanned copy of the original bill of lading.
Thank you, Jagan. A question from one of the viewers: Can we release a delivery order to the consignee against a bank guarantee, whilst the OBL is still held at a given destination due to the lockdown? Thank you.
Well, there is no obligation for the carrier to release cargo against a bank guarantee. It is a commercial process. Please understand that carriers' liability insurance will not engage if carriers have released cargo without BL. Having said that, it's a common practice, common commercial practice, that as long as the bank guarantee is good, the carrier would perhaps try to ensure that it is from a good bank. They would be agreeable to release it, provided the value provided in the bank guarantee is sufficient and the time limits are also sufficient. Yes, you could do it, but please ensure that you factor in, is the bank good enough, so that if there is a problem, they would be willing to pay. Number two is, what is the value in the bank guarantee? Does it also cater for those costs which you may incur in defending or pursuing? And third, look at the time limits as provided in the contract. In English law, claim for property is for 6 years. In other jurisdictions like India, it's 3 years. So if you provide for a shorter time span, you may actually have a problem that there is a gap.
Jagan, we have a question from one of the viewers. It is about the option to, can a customer cancel or destroy an OBL and then do a telex release or change and have a CWA bill? There are some shippers who face situation where they have the switch BL in hand, but they are unable to surrender it. And they say, we will destroy it on our part, and we will, and in the meantime, they request for initiation of the telex release process. What are the risks involved in this? Thank you.
Under common law, a carrier has an absolute duty to release the cargo to whoever has the original bill of lading. The question is, you require just one rotten apple to game the situation and say, listen, I will, destroy the OBL, I will do this. And then he actually negotiates, sells it to someone. And a carrier is then faced with a situation. He releases the cargo on the basis of, a telex release, which he has done in good faith. And someone else comes with the OBL. So, while you could do it, this is a commercial risk for a carrier to take, and a carrier is liable at least for the value of the cargo to he has released. So this is something, a commercial risk, which a carrier has to decide.
Our next question is, if the bill of lading is consigned to order and the documents are given to the carrier, and the documents have been given to the courier, what the receiver has is the shipping line does not release cargo.
As I said, it is quite.
What if the receiver has, as the shipping line does not release cargo?
It's quite possible, invariably, I'm unaware of any shipping line who do not release cargo without a bank guarantee. So, if the documents are with courier, the easiest and the best way is to approach the shipping line and say that, I'm willing to provide some alternate security, which could be the bank guarantee for value which is acceptable to release the cargo. If, let's say, in the worst case scenario, a shipping line does not do it, the only other option which perhaps is available is to go to courts. But unfortunately, the court processes in most of the jurisdictions are not as fast as the commercial processes available.
Okay, again, Krishnan, there's one question asking about how much container cargo volume impact for Indian ports. I think that this is something which time has to tell. I will skip that for the time being. There's another question. Please confirm regarding acceptance of scanned deals by the major container lines. I guess you had mentioned something during your presentation. Which are the companies which are accepting these at this point of time?
See, some of my clients did mention that Maersk, CMA, CGM, and MSC are doing it. I have not seen it in practice, but I did see their notices, which are there. I am sure that there are viewers from India who have experience on this. The problem is Maersk, MSC, and CMA, CGM are big companies. They have their own risk management system. They deal with claims themselves up to a certain limit. While this might be right for them, this might not be necessarily right for everybody else. Having said this, so yes, it is quite possible to take a commercial decision like what they are doing. But as of now, to my knowledge, Maersk, CMA, CGM, and MSC are doing this. I think that is what was asked on this specifically.
Okay, thank you. The next question, in the current situation regarding export direct delivery cases, the port is working 24 hours, but there are road restrictions in many countries from say 8 p.m. to 6 a.m. the subsequent day. During this restriction, the cargo is not available in the port. So this road restriction, can it be taken as a force majeure to counter the argument on demurrage? And due to this, the road restriction, the vessels have to stay longer as well. So
Well,
did you get the question?
The question is, if the charter party, I believe this is in a charter party situation, if the charter party has a force majeure clause which takes this provision, yes, charters have the benefit. If it does not have, because force majeure is a creature of the contract, because there has to be a contractual provision, my view is you would not be able to do. You would then look at whether you could consider frustration. I think, it's impossibility of performance. It is not a longer delay for performance. That doesn't come. You can still perform it. So this is not frustration. My view is, although the situation here is novel, I think what you need to look at is who's at risk. The charters are more at risk for the cargo than owners. Therefore, they should be liable for those costs associated with it.
Okay, the next question is a situation where banks are not involved and consignee is not able to get their endorsement in the letter of indemnity. In such circumstances, can we accept a blank check from consignee along with the LOI to safeguard the carrier's interest? What is the legal view on this?
Some years back in Dubai, having a signed check was better security than anything else, because if the check bounced, then it's a criminal offense. That was my understanding. But I think the rules have changed. The problem is, even if you have a blank check, there may be no money in the bank. Yes? And the person may argue it is not his signature. So there are many other issues which are there. So as long as you are confident that the check will pass through, fine. But if you are not confident with the check being, passing through the bank with sufficient funds, then, the owners or the carriers are accepting risks, which put them in a predicament. Insofar as the legal view is concerned, I think, yes, they would be liable, to anyone who's a holder of the BL. So if someone else, a third party, comes to the BL, while the owner or carrier can say, listen, I have got a blank check, and I will try to enforce this check. If the check bounces, the carrier still remains liable. So this is where it all boils down.
Okay, the next question is regarding electronic BLs. Jagan, you did touch upon the electronic BL system. Some of them are already in place, but not picked up in a big way. Are there any reasons why it did not pick up in a big way? And if it is agreed, what is the level of understanding which can be given to the users so that this becomes widely used?
I've actually, in 2013 or 2014, I did write my first article on electronic bills of lading. I'm not trying to sell an article on that. But, if you look at Bolero, it was right from 1990s, they have been, present in the market. The problem is, one is the legal issues. Some jurisdictions still want paper documents. That's one. Number two, why do you want to change the wheel when everything is going on fine? So although electronic bills of lading have been there for quite a few years, there was no specific need. That is the reason why it has not picked. Insofar as the process is concerned, I think the process is pretty easy. The system providers are more than happy to work with companies to make it as much user-friendly so that it can be done. The process is just similar to what a shipping company will do to issue a bill of lading. The main use of the electronic bills of lading is more for the trading partners, wherein they can actually transfer or negotiate or send the documents to bank using electronic functions. So they would have to take other documentary systems which these companies also provide. So that is something for the traders, for the users to deal with. But electronic bills of lading, I don't think there's a problem. Most of the companies have a system, their own in-house system, which is already complex. I believe the electronic bills of lading systems, which given by different platforms, are similar in nature, and it will not be a difficult issue to get everybody on board.
The next question is, if the case he is not content of the bill and wants to convert to a CWA bill, should line change it to CWA bill, trusting the shipper statement, or how do they protect their interest, line's interest?
I think, in this case, the shipper is actually giving the details for a bill of lading. And basically, if you look at the Hague or Hague-Bisbee rules, it says on demand, the carrier will issue a bill of lading, a negotiable document of title, so to say. And if the shipper is not asking for it, he could, if it has not already been issued, I don't believe there's an issue on this. Let's assume that someone does come at the destination says that, he or she are the owners of the cargo. A carrier would ask for the original bills of lading, and since none have been issued, a carrier would be entitled to defend the claim against them. So I would probably say that yes, if a bill of lading has not been issued, if a carrier does issue C-way bills, I am aware that some carriers do not, as a right, issue C-way bills, but that is because of their own trade processes in that company. They ask for BLs to be surrendered. I don't think there's an issue. The other way is actually you can print out the bill of lading and surrender it. It actually functions similar to a C-way bill.
All right, thank you very much, Jagan. I think we have covered all the questions. They're just coming in different forms now. So thank you very much for the presentation, Jagan, and thank you to all the participants over here. We had more than 200 for the bulk of the presentation. There were lots of questions, and we've tried to, streamline and have to skip repeat questions. Feedback forms will be sent to all the participants, and we will also get the slides in case, when you fill out the form, you'll get the presentation from Jagan. Feel free to leave any comments in the chat box. And our next webinar is going to be planned for next Saturday, same time. You'll get the information soon. Thank you very much all for attending, and we really appreciate it.
Thank you very much. It's been a pleasure to be involved in this presentation.
Thank you very much, Jagan. Really appreciate that. Thanks everyone for joining.
Thank you.
International signal